Thank you. All right. I have two more cases on my calendar. Courtroom 2, who do we have next?
We have position number 12, Mr. Sparks.
Oh, three more cases. Okay. This is Mr. Louis Sparks, accused of a violation of the law regarding squatters, 16-7-21.1. Case number is 25 CR 000147E. Offense date appears to be December 20th, 2024. Now, Miss Franklin Brennan, did you get that phone number that was sent to everyone? Okay, thank you. Okay. Mr. Sparks, you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is going to be Mr. Michael McLean. Any priors?
Well, no squatting or history. 2024. He got an open case, ag assault, crude 10 to 3rd, criminal damage to property, 2nd degree, obstruction, simple assault. It's 24 PI 002815. Open theft by conversion, 22 SC 182232, 2018 FTA.
Miss Allen?
Thank you, Your Honor. This is an incident from December the 20th. There was actually a hearing in magistrate court in front of
Judge Ashley.
Judge Ashley on the 7th. He found probable cause for a count of squatting. The owner of the location at 5558 Union Point Place in Union City had to do a private action for a warrant because the defendant refused to leave the premises. He's filed in a bunch of sovereign citizen, UCC, gobbledygook, and has an AKA. The victim in this case is Mr. Douglas Walls, the owner. Judge Ashley issued a $10,000 good bond after hearing on this matter. I would note that the open 24 PI case mentioned by pretrial is from April of 2024. The defendant in front of you was released on bond following his arrest in that case. And as part of that bond, he's been ordered to stay away from the location. That's the location where his wife and his 5 children live. And the case in Superior Court is an aggravated assault against her in front of those children.
It looks like you can still be removed from a property even when you rely on confusing arguments that make no legal sense, which honestly surprises me because the courts only follow real laws, not made-up rules. Now we move to our next situation, where a woman tries a completely misguided legal strategy that ends up backfiring in a big way. Her decision turns out to be one of the most careless choices she could have made, and it ultimately costs her thousands of dollars. That it's a perfect example of how ignoring proper legal advice can turn a small issue into a very expensive problem.
So not only is he fighting to stay at the property, even though he has no legal right to possess or be on the property, and the owner of that property had to go through the court system to get him out, the court has already ordered him to stay away from that location because of the open felony aggravated assault. We're asking to keep that $10,000 good bond that Judge Ashley put in place. I'm guessing it was for a reason. It might be part of the 60 pages of things that have been filed into this case and the gobbledygook and someone who just frankly refuses to acknowledge that they've been ordered to stay away. We will continue to try to be in contact with the victim in that 24 PI case, Your Honor, Mrs. Duncan, and I've already alerted the DA's office that this gentleman is now back in jail for a violation of the bond in that case. And so that's where we are. We'd ask for no contact with the gentleman who owns the location, Douglas Walls, or anyone else who's living there, to stay away from 5558 Union Point Place in Union City. No drugs, alcohol, or weapons. Thank you.
Mr. McLean?
Your Honor, my client, Mr. Sparks, is a high school graduate. He has been working in the ministry for a year and a moving company for 8 years prior to that. Based on the charges, he's also been in Georgia quite some time, over 11 years. He's 42. Your Honor, based on the charges, we understand what the state has been concerned about and is concerned about we would ask the court to consider a signature bond, and if not a signature bond, then something like a $1,000 or $2,000 surety.
It's going to be a $5,000 surety bond. I'm not sure whether he's got a bond surrender in his 24 PI case 002815. I just see some notes about that, but y'all can look into it.
I didn't see that he had a bond surrender. It's just real clear he can't go back to that location as a condition of his bond. It's a $20,000 good bond, I believe.
Okay. But meanwhile, it is a $5,000 surety bond for this particular case to stay 500 yards away from 5558 Union Point Place in Union City, 30291, to have no further contact with Douglas Walls, no illegal drugs, no alcohol, and no weapons and no firearms. And his next court date will be January 21st.
For someone who seems very alert, it's surprising that she completely missed the point the judge was trying to explain. The judge gave her two choices. She could admit she was in the wrong and possibly be asked to leave the property the same day, or she could request that the court accept her late response, which would give her 7 more days but also add a financial judgment against her now. Think about it. Which option do you imagine she's going to pick? Instead of taking the straightforward path, she leans toward the one that creates even more problems for herself.
All right, so I've got Miss Carol Ann Ellis. She is here. She's out of the breakout room, so we can go ahead and go forward on position number 1. All right, so Miss Ellis, you could come into the camera for me.
I'm here by special appearance, Judge. As a lady.
Hold on one second. So Miss Ellis, I just need to swear you in first, and then you can make your statement. If you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I stand in honor and affirm that my words shall be truthful with full reservation of my rights under God's laws and natural law.
Okay, you can put your hand down now. Thank you. All right. So I have already reviewed the case. I remember Miss Ellis from previous dispossessory where there was, long story short, that the parties, at least at that time, did agree that she had taken subject to a valid lease. And that they had not pled for non-payment, and I'm assuming this is where this new dispossessory is based on the non-payment, based on the lease that she had with the previous owner. Is that correct, Mr. Thor?
That is correct, Your Honor.
Okay, and it looks like so, Ms. Ellis, I looked that you did file a late answer in this case. I saw that you had said you had emailed your answer or some sort of response to the plaintiff. That does not count as an official answer. So it actually, your answer does have to be uploaded into the file within the 7-day time frame. So it is a late answer. I did also just review that I didn't see any legal defenses or counterclaims in this. So this would technically today be a judgment on the pleadings. So Mr. Thorpe, if you'd like to present your case.
Yes, Your Honor. So this was filed for non-payment of rent. Service was effected on December 10th. No answer was filed. Defendant is in default. We request a immediate writ of possession.
Okay, with a judgment on the pleadings, it would be 7 days from today. So that would be the 5th of February. Since you, well, technically,
that'll yeah.
It was a late answer. You are right.
May I, Judge?
Yeah, just 1 second. I'm just getting his case first, and then I'll come to you. Let's see. Yeah. Okay. So based on the answer being filed late, so you're just seeking the writ. You don't want the answer accepted, so you're just seeking the writ.
Correct, Your Honor.
Okay. Okay. So, Ms. Ellis, before you make your statement, I just want to make just a general statement about the fact about the answer being late. Okay. So here are the pros and cons. You filed a late answer. Like I said, there wasn't any legal defenses or counterclaims in the answer that you did file, but you did file a late answer. If you want me to accept that answer, that would subject you to being subject to a money judgment in the case. However, it would give you an additional 7 days before the plaintiff could file for a writ of possession. If your late answer, if you choose to have me not accept your late answer, then the writ would be available for them to apply for as early as today, but you would not be subject to any form of money judgment that they could use to collect on. But you would have to, the writ would be available to them a little bit 7 days earlier than it normally would have been.
There's no question that she's fully capable of understanding what's going on around her. The issue is that she refuses to actually listen to the judge or take in the information being explained to her. It's as if she's hearing the words, but choosing not to process them at all. Moments like this make it clear how important it is to stay calm, pay attention, and think things through before reacting.
So I guess my first question, so I guess if you'd like to make your statement, but then I'm going to need to know whether or not you want me to accept your late answer, because if you want me to accept your late answer, there would probably be a money judgment associated with your order, but the writ would be applied for in 7 days. If you do not want me to accept your late answer, it would just be a writ available today or whenever they filed for it already, I believe. The writ would be signed today, but there would not be a money judgment against you. Okay? All right, so if you'd like to make your statement now.
So under what authority is the abatement that I filed could not be the answer? Because is it ethical for the court not to accept the abatement that I filed, because that's how I usually filed, and it was always never a problem?
There's nothing filed.
So I have that evidence because I went into the court and they showed me that was filed, and they said to me, that's what you were stating this court case on. So I want that answer to be put in place as the answer for that debate.
If you file the late answer, like I said, it would subject you to a money judgment. I'm not sure what you mean in terms of an abatement, but the rules for dispossessories are pretty simple. If you have not paid your rent, they will file based on non-payment of rent. They'll issue a demand. And then if you do, and essentially, unless you can show that you've got some sort of legal defense,
I do.
The dispossessory itself, and what would that be?
I do have legal defense. First, I want to repent for all my debts, and I like to rescind my prior actions to start over. I have evidence that I filed a case. I filed to buy the premises from the real party of interest. That's why I was asking this attorney if he does have evidence of who's the real party of interest on this property. Because even yesterday, I was speaking with the owner of the property, tell me that I need to send in a GAR and my proof of funds. So this is not about possession or monetary value, because I have all that evidence.
So Ms. Ellis, in the previous case, it was shown that this plaintiff purchased the property at foreclosure. You had a lease with the former owner, and like I said, there is nothing along those lines. Hold on one second.
I do have that evidence, Judge, because we never get to that situation because of all the situations that were happening. I do have all that evidence.
Do you want me to accept it? Miss Ma'am, do you want me to accept your answer or no?
Yeah, I want you to accept my answer so I can move forward.
Even if she doesn't make the top of the list for the most misguided legal arguments, she certainly earns a spot for making some of the most questionable decisions. Now, let's turn to our next case, involving a man who claims he's a king and ruler over his own domain. He insists that he has the right to access any property, whether public or private, anywhere in the United States. As you can probably guess, his bold claims are about to run straight into reality. This is a perfect example of how misunderstanding the law can lead to serious consequences, no matter how confident someone feels.
All right, I will accept your late answer. That does mean, Mr. Thorne, that the writ would be available in 7 days, but you can seek a money judgment. Ms. Ellis, you can make whatever argument. I've read through everything you filed in the case. It does not present any sort of legal defense to this dispossessory proceeding. All right, so Mr. Thorne, she does want her answer accepted. So if you'd like to present evidence on the rent owed, you can do that if you'd like.
I believe you have a copy of the lease agreement, Your Honor. Monthly rent is $23.50 with a $30 late fee. Rent has not been paid since October. It was found, I guess, in the prior case handled by the prior counsel that rent had been paid through September. So October, November, December, in January, and late fees would be $9,520.
Okay, you said it was $2,350 per month,
Correct.
and then
With the
that
thir-
would be.
And a $30 late fee.
So you're not seeking. Okay, so you're just seeking through January.
Yes, Your Honor.
Okay. Let me just check.
And may I ask a question, Judge, if that's okay?
Just 1 second. Just 1 second.
Okay,
Yeah.
thank you.
1, 2, 3, 4. 4.
Do I have that wrong?
Okay. So I did. So that's 4 months. October, November, December, and January at $23.50 per month, plus $120 and $30 late fees per month. That amount is $9,520. All right, Miss Ellis, what would you like to say?
So I just need to ask the question. So if the payment is not received while I'm negotiating with the owner to buy the property, you said in 7 days, what's the next step?
Well, they're not required to accept any pay. If they choose to accept payment from you, that would cancel the writ in this case. So if you come to them and you guys are able to work something out and they agree to accept funds from you, that would cancel the writ of possession in this case. But again, that's something you'd have to reach out to Mr. Thorne to talk about. But again, like I said, if they did accept, the triggering thing is them accept. You can, if they accept it, if they accept the funds, if you send in funds and they accept it, that would mean they would have to cancel the writ. But otherwise, the writ would be in place.
So what is being done today? You're filing a writ for possession in 7 days? Is that what you're doing?
Okay. The landlord will be able to, because I'm accepting your late answer per your request, the landlord is seeking a money judgment in the amount of $9,520. And then they will be able to apply for writ of possession by 11:59 p.m. on next Wednesday, which is the 5th of February.
So that will be a new case or the same case?
This is this case, ma'am. This is the order in this case.
So will I be back in court or not?
This case is going to be over as of today. This will be a final order in the case. I will enter that order, and then the writ will be available to them to apply for at 11:59 p.m. on the 5th of February.
So is this a default judgment that is going to be closing out today, you're saying?
This is not a default judgment. It's a judgment on the pleadings. You didn't present any legal defenses. I'm accepting your answer, but there are no legal defenses or counterclaims regarding this possessory. So they're going forward today just on the pleadings. Based on the pleadings, the amount owed is $9,520. And like I said, one more time, the writ will be available at 11:59 p.m. next Wednesday, which is February 5th.
Thank you.
All right, so that'll be the order of the court. Mr. Thorne, I will prepare that order. Okay?
Thank you, Your Honor. I appreciate it.
Thank you. Have a good day, sir. You're both free to go.
I'd really like to see how he plans to use his so-called authority once he ends up in a place where none of those claims matter. Let's see how that imaginary power holds up when he's in a controlled environment and has to follow real rules instead of the ones he made up. Something tells me the situation won't play out the way he thinks it will. Reality has a way of reminding people that the law applies to everyone, no matter what title they give themselves.
Mr. Tyrone Harris is at the medical unit. He is accused of criminal trespass under case 24 CR 8301G. Mr. Harris, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney, and representing you is going to be either Mr. Bartel or Ms. Kim or Mr. Haddad. Okay.
No, Judge. So he's proceeding pro se.
Pro se? Okay. Thank you. Mr. Harris, you have a right to an attorney. If you choose to waive your right to counsel, then you will be depriving yourself of legal experience and expertise. If you decide to represent yourself, you are responsible for understanding the criminal laws and procedures and how they affect your personal freedom and your any other matters such as open cases, your job, your residency, or any other licenses you may have. And also what kind of impact it will have on your criminal conviction record if you have one. But it's really up to you whether you would like to have appointed counsel at no expense to you or whether you'd like to represent yourself. So, Mr. Harris, how would you like to proceed in terms of having an attorney?
No, I'm okay. I represent myself. I'm a monarch or a royal sovereign. I have divine rights of a king and also sovereign rights. I have non-monetary conditions in the state of PA, personal and secure bond in Maryland, and I got surety bond here in GA. I have eminent domain, so any private property that was established like in this land is for public use for myself.
Free sovereign citizens up, free idiots down. And this one is going down proudly wearing his royal full regalia. Now we move to our final case of the day. A sovereign citizen duo who somehow believes they can enter a residential agreement with a long-stay hotel, then turn around and claim that the lease wasn't with them, but with their so-called trust.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
How do you want to proceed with one count of criminal trespass cited against you from December 25th, 2024?
Not guilty. I had a comp going on for a bus ticket back to Tampa, Florida. I only been here 2 days, and then I got arrested. I already established and shown the paperwork of my sovereignty.
Okay, well, that is certainly not a very pleasant welcome to Georgia. So, as you are planning to enter not guilty, I am going to arraign your case. Would you like me to read the accusation, or do you waive a reading of the accusation?
I can waive it.
Okay. So, Mr. Tyrone Harris in Fulton County, Georgia, you are accused of criminal trespass at the Greyhound bus station at 232 Forsyth Street, Atlanta, Georgia, Fulton County, on December 25th, 2024. Your accusation is 24 CR 8301G. This is a misdemeanor offense. You are legally presumed innocent of the charge, and upon your entry of a not guilty plea, the case will be scheduled for trial before the division judge. At the time of the trial, the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt. At the time of the trial, if the prosecution prevails and overcomes your legal presumption of innocence, you could be found guilty and face a possible penalty of up to a year in prison and or up to $1,000 fine. Given this information, and the division judge will be John Mather, how do you plead to this particular misdemeanor offense?
Not guilty. One of the officers said he was going to compensate me for a bus ticket beforehand, so probably on a radio record. So it was just a lot. It was a misunderstanding that was going on. Like I said before, I have divine rights of a king and also a sovereign citizen.
Well, I'm sure those rights can come in handy when you go to trial, but presently, I'm exercising your right to an arraignment. And your right to arraignment is you will have a trial. It'll be scheduled before Judge Mather. You presently have a $2,000 good bond. And if you do make bond, make sure that you give us a good mailing address so that we can send you notice of your trial date. Failure to appear for your trial date can result in a bench warrant for your arrest.
So even if I have a surety bond, which is a creditor that's guaranteed to have his debt paid by the debtor, I still can't be released before trial?
You can come up with $2,000 of legal U.S. tender, or you can go through one of our bonding companies. We have lots of them in Fulton County, Georgia. Or you can pledge equity in any real estate as long as you have legal title to that property that the sheriff's department will accept.
So even if I have, even in the Commonwealth,
the answer to that question is no. The answer to that question is no. I've already given you the three options.
So you're just going over something that you're not even supposed to be going over.
You're absolutely correct.
Okay, I appreciate that for that information and for that truthful answer you said. So.
Understood. Thank you. All right, Mr. Harris' case is been arraigned and further notice for trial.
Well, you can reserve your right to be a toothless, tax-dodging exemption explainer all you want, but UCC 1 to 308 protections don't magically apply to a long-stay Sunesta motel.
All right, let's do position, which is going to be 30 on my calendar, that Mendez.
Yes, Your Honor.
Where is the party for that Capital Holdings at Grizzy list?
Oh, we're here.
Can you turn that camera on? Great. Can you turn the light on in wherever room you are?
Yeah.
Yeah, I mean, listen, this is court. I don't know why people be acting otherwise.
Okay.
Are you laying down? Can you sit up?
Yeah, I am. I don't feel too good.
I know, but I can't see you too good. All right.
You know?
And what's your name?
I would be part of the others. So I'm Ryan Clayton McClendon, TTEE.
Okay, and you live there?
I'm with Madriana Michelle Payne Mendez, TTEE.
All right, let me just get you under oath so we can go through it, okay?
All right.
Can you raise your right hand? Physically able to do so. Swear affirm to tell the truth under penalty and perjury of the law?
Yes.
All right, excellent. All right, counsel, Attorney Lyon, let me just ask you a couple questions regarding this matter, and I'll, of course, ask some questions of you as well. Mr. If you can just keep your camera on, don't, no reason to back and forth. We're doing the hearing. All right, so, counsel, is this a written lease with Miss Miranda and Payne Mendez?
It's an agreement to stay, Your Honor. The property located at 4601 Ridgeview Road that operates as a Sonesta extended stay hotel.
I see. This is an extended stay. Okay.
And so Miss Mendez agreed to a rate of $99 per day plus additional state and federal tax. At the time that she came onto the property, that would be May 30th, 2025.
Okay. And since that time, there's been no monies paid, is what you're saying?
There have been payments. The last payment made was July 13th, 2025. Miss Mendez paid consistently between May 30th and July 13th, at which point all payments stopped. My client sent a notice of obligation to pay on July 16th, to which no response was made. And then we sent an additional letter that I drafted on July 28th, 2025. And there have been no payments since July 13th.
Okay. All right. And this gentleman, you guys have ever accepted money or had any communication with Mr. Orion, TT, the trust here? I'll just ask you, Mr. Lyon, and then I'll come back to you.
My client's aware that Mr. McClendon was staying in the room with Miss Mendez. The trust issue was brought up upon service of the dispossessory summons to my client, where I believe it was Mr. McClendon indicated to the individual who served him and then later to the desk clerk that it should have been a trust that was staying at the property, but at the time of registration and since no time since then was a trust substituted for the individual who registered.
Okay. All right. Well then, Mr. McClendon, I just want to ask here, have you been paying at this place?
Well, we're both here as a special appearance to only challenge jurisdiction. So Sonesta only should have the trust name. We don't understand how another name is on this summons because we didn't give them another name. We gave them the trust, and anything that we signed with TTEE behind it, UCC 1-308, all rights reserved. No. So we understand this is a commercial matter, but they have to deal with the trust. So there's no reason why the trust should not have been put there. And I have a witness. So she's a witness. I'm a witness. We also have, her name is? Alicia is also a witness.
So let me ask it, because these are always interesting to me. Okay. And so are you asserting that just by virtue of you being a trust, that this court doesn't have jurisdiction in this matter?
Exactly.
And I would tell you you're wrong.
It's a commercial matter, and equity courts deal with trust.
It's a landlord-tenant matter. And in fact, you specifically are an all other and not a specific tenant, because I don't understand did you sign and actually?
Yes, we both signed, reserving our rights.
No, I'm not referring to the answer. I'm referring to the actual initial agreement to rent this particular, or not rent, but to stay in this particular Sonesta.
Yeah.
Okay, and then this, and just to confirm here, because I'll be frank, what most likely will happen is there'll be no money judgment, because if the parties that answered aren't the parties that are actually the ones that are staying there, there could be no money judgment. I have in my discretion about at least giving you either a written stanter and or 7 days. But I like to remind folks that a trust does not in effect usurp or take away my authority. There are things that do that, but that doesn't happen, particularly in a situation where we're dealing with hotels or dealing with extended stays. So I don't see that Miranda specifically answered, because she's not a trust. And if you're saying or holding,
she's the representative.
Yeah,
she's a representative. And she's a trustee.
I understand, and I'm looking at the paperwork that you've supplied, and but again, that trust just means it is a trust. It doesn't do anything really different.
The trust, we know, is we live outside of that trust. We live inside of that trust. Everything else is outside of the trust. So therefore, whenever we're dealing with any commercial matters, we have the trust put down, because that means if anything goes on, anything goes wrong, it can't be any court that we go into, because we are trustees for the trust.
That's cool.
So we don't put our name on it. We put the trust name on it.
Got it.
We represent the trust.
I got you. It's like being a business. I'm here for it. But a business can be evicted too. It's not a special court that requires that. And I believe this was a state court matter. So that kind of resolves the issue.
Court is best.
But it doesn't have to. Landlord-tenant matters don't have to be brought in Superior Court. I just don't like when people kind of half know law. It just kind of makes the process unnecessarily.
Well, I'm sorry. I don't have no law. I know you don't. Trust law is different than every other law, and it's supposed to be handled in a certain jurisdiction, a certain venue. And that's what handles trust. They don't handle. Every other court handles individuals. We're not an individual in this case.
Well, it looks like the sovereign citizen gobbledygook is exactly what it sounded like: nonsensical, pointless, and instantly self-defeating. All right, guys, that wraps up the video. I appreciate you sticking around to the end, and I hope to see you in the next one. If you liked the video, hit that like button. If you disliked it, hit the dislike. But don't forget to drop a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out. Music plays.